I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely.
If you represent yourself, you're prepared to go forth today?
Yes.
Court does call the case of the People versus Larry Lee.
Good afternoon, Your Honor. Marie Townhouse, Assistant Attorney by People.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess, currently representing Larry Lee.
Your name, sir?
Larry Lee.
All right. Mr. Burgess.
Your Honor, based on representations or communications I received from the court, Your Honor, I filed a motion to withdraw. I also received a letter today from Mr. Lee that the court made me a copy of, indicating he wants to represent himself. So based on the motion I submitted, as well as this letter, I'm asking the court to allow me to withdraw as his counsel.
And just so that the record's clear, the court received from Mr. Lee what were, in this court's opinion, I did not read them fully and only had a staff member relay them to me, were, I would say, privileged communication to the extent the privilege would still exist between Mr. Burgess and Mr. Lee. That is what I, based upon looking at them, what I presumed that they were. That is what I presumed that they were. At that juncture, I informed counsel that I had received them. Because I had viewed them as privileged, I had indicated that I would not let the people see them, but that Mr. Burgess could come by our office and look at what had been received. Shortly thereafter, I received Mr. Burgess' motion to withdraw. And basically that was going to be heard today. Almost immediately thereafter receiving that, I then received in, I guess, in our office mail or however it got to me.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Okay, folks, we're jumping straight into the preliminary examination of Larry Lee's case, a real legal roller coaster. Right off the bat, tensions spike as Mr. Lee goes back and forth on whether he wants counsel or to represent himself. Already, we see the courtroom chessboard in motion, motions to withdraw, letters to the court, and a defendant asserting his constitutional right to self-representation. Keep your eyes peeled, because the judge is about to lay out the heavy consequences of this choice. And trust me, this isn't just paperwork, it's high-stakes maneuvering, where one misstep could cost serious time behind bars. Who do you think is making the smarter move here? The lawyer pushing to withdraw, or the defendant taking the wheel himself?
A letter from the defendant saying all kinds of different things, but indicating that he did wish to represent himself. That letter that he sent was shared with both sides. Today, I provided a copy to the people and also to Mr. Burgess in this case. All right. Is anything from the people?
Your Honor, just that I've spoken to Mr. Burgess about this matter. I don't have an objection to this motion. That's of course discretion. As far as I'm concerned, we've had communications about this case. He has fought diligently for his client.
All right. Mr. Lee, do you not wish Mr. Burgess to represent you in this case?
That is correct, Your Honor.
All right. And the other thing, you wish to represent yourself? Or do you wish the court to sign an order that permits the Office of Manager Assigned Counsel to appoint counsel to represent you?
I would like the latter.
So you want new counsel.
Yes,
So you want at this time and I think it's on page 2 of your communication indicating that you wanted to represent yourself. You want the court to disregard that at this time.
yes, sir.
You understand that because I'd be appointing new counsel, that's going to require that this matter be adjourned to allow counsel to get up to speed on your case.
Uh, okay. I was unaware of that. That, are we, talking a 1 month or a 2 week adjournment? Just curious.
Well, it's wherever the court, I've got a very tight schedule, but we will, what day?
August 19th, Your Honor, would be the date.
It would go out approximately a month.
Okay, I have some upcoming surgeries, and so I, will then, like to just represent myself, because I don't, they're very serious surgeries, and so I don't have the
Okay, but
time to,
I,
wait.
I understand that, but when do you think, if you represent yourself, when do you think your examination would be?
I would, object to any further delays, and I would like as soon as possible, convenient with the court and everyone else. I'm prepared,
You're prepared to what?
I'm prepared to, take the first available date for the examination as soon as possible.
Well, I don't know what you're asking.
Here's where it gets really tense. The judge is grilling Mr. Lee on whether he's truly ready to proceed with his own defense, because representing yourself isn't just brave, it's legally perilous. Notice the discovery issue. Mr. Lee has barely seen the full evidence, only a couple of pages, and now he's expected to go up against seasoned prosecutors. This is a classic example of why courts caution against self-representation. You're held to the same standards as an attorney, with no room for mistakes. Audience, think about this. If you were in Mr. Lee's shoes, would you risk it or insist on having a lawyer? The drama here isn't just courtroom tension, it's a legal tightrope walk where every word counts.
Asking me to do, Mr. Lee. Have you reviewed all of your discovery and everything?
As far as I know, the discovery was just, 2 pages of the interview with the detective and the victim. I have reviewed
I'm
that.
going to probably believe that there's more than just
Correct.
2 pages.
Correct, Your Honor.
I just provided copies too, Judge, when he was at my office in May 8th.
So I would need copies of that.
I mean, Mr. Lee, you're not, would I be correct that you are not prepared to go forth today to preliminary examination yourself? I mean, because you keep going back and forth, you want counsel, then you want that.
So I am prepared to go today. Absolutely,
If you represent yourself, you're prepared to go forth today?
yes.
So what do you want me to do, Mr. Lee?
I would like to proceed today.
Okay, you understand that it cannot finish today.
Sure. I agree. That's fine.
Would the people have a witness they can start with?
Your Honor, we have a witness we can start with. I will say for the record, I do have concerns that if Mr. Lee is going to be representing himself, he's doing so without having all the discovery. And he, of course, will be held to the same standards as any attorney would be held. So a lot of concerns from the people, but we do have a witness available if that's what the court is inclined to do.
Is that really what you want to do, Mr. Lee?
Yes,
I think I'm going to be honest with you. I think you're just telling me yes, thinking that you're going to get a quicker date. And I am not clear that you're ready to go because you only talked about 2 pieces of paper and counsel's telling me there's a whole lot more in this file.
I understand. I'm willing and ready to go
Do you
today.
have a copy of the discovery?
My attorney hasn't provided me with a copy.
Sure, Judge, I gave it to him on May 8th. He was at my office. He got a
Well, the
copy
2
of it.
pages, yes, that's what I have. The
No.
other stuff I don't have.
Your Honor, for the record, not only is there a full police report, but there's also body camera footage. That again, it might be best to review before.
Have you seen the videos, Mr. Lee?
Well, I was there. I'm assuming they're referring to the body cam footage at.
Well, I don't know. You're making assumptions about what exists, and I don't know. Have you seen the body cam footage, Mr.
No. If you're, no.
Do you still? This way. Um. Would the people be available? It is gonna be a mess on the afternoon of the 8th. It's a Friday.
August 8th, Your Honor?
Yes, ma'am.
Yes, Your Honor.
All right. Are you gonna be able to, so if I set it on the 8th, sir, and I'm sort of pigeonhole you in on a Friday that I normally wouldn't hold them, but if I do the 8th, are you still wishing to represent yourself or do you wish an attorney?
I'll represent myself.
Your Honor, the one thing I would like to add, because as I stated, we were ready to proceed today. The victim is here on this visitor's waiting since this morning. Victim has also been here previously. Waiting for an exam. I would just ask that we have no further delays on the 8th.
Yeah, if I'm gonna be done. If you're saying, Mr. Lee, that you're representing yourself and I set this on a special date, I'm not going to at that time. If you wish an attorney, then I'll have to deal with that, but I'm not going to let a delay happen. Okay, we're gonna go on the 8th.
Yes, Your Honor.
Is that what you want to do?
Yes.
All right, I'm just,
Double checking. Days works.
pardon?
Days works for the people.
All right. So that's what I would set. I will advise you at this time, Mr. Lee, you understand that you are charged with the offense of criminal sexual conduct in the 4th degree involving force or coercion. You understand that, sir?
Yes, sir.
And that involves us. You understand that, sir?
Yes, sir.
You also understand that this is a high court misdemeanor punishable by up to 2 years incarceration, a $500 fine plus court costs, mandatory HIV and STD counseling, and DNA was taken or have been taken upon your arrest. You understand that, sir?
Yes, sir.
You understand also that this, under the SORA statute or sex offender statute, is a tier 1 offense and would require registration if the victims are 18 years or older. You understand that, sir?
Yes.
All right. And also other requirements, but I'm presuming that the victim is, that's the only one that would be applicable in this test, in this case.
Yes, sir.
You understand all of that? You understand that if you proceed to represent yourself, you do so at great peril, and usually doesn't not necessarily work well for people when they represent themselves, but you are constitutionally entitled to represent yourself. You understand that?
Yes, sir.
You understand also that the court is going to make the assumption or presumption that you understand the Michigan court rules and the procedures used in a courtroom. You understand that, sir?
Yes.
You understand that the court would not be there to assist you in any way regarding this case. You
Yes.
understand that, sir? And you understand that you will not be, the court is not going to treat you worse and not going to treat you better than any attorney or the prosecutor in the case. You will be held to that same standard in conducting this.
Yes.
All right. Understanding all of that, you still wish to proceed representing yourself, sir?
Yes, Your Honor.
All right.
Your Honor, just for clarification, does the defendant want standby counsel?
He has not asked for it. I'm not offering it.
I'll take one if it's available. Thank you.
Well, there's going to be a funding issue regarding that. I'll make that determination as to whether or not there be standby counsel, because that can be done elsewise other than this. I will adjourn the preliminary examination in this matter to August 8th, 2025 at 12 noon. That's before me.
Bond violation will follow.
Yes, there's that and the bond violation. Yes.
The defense is requesting, you to, examine the information between myself and my attorney, because I am alleging that I did not violate the, bond, the condition of the no contact order of my bond, and, witness tampering, that the prosecution says that I'm guilty of, and the text messages prove,
You're asking me to look at information that would be relevant to the bond hearing?
the text messaging between myself and my attorney, and then the Google AI searches that prove my motive and intent for making the phone call between myself.
Sir, this is, and you're asking me to look at it in reference to the bond violation.
Yes, because I think it should be reinstated.
I will address that on the 8th.
Okay, thank you.
Okay, I'm not making a guarantee I'll look at it or not. I don't know whether or not it's relevant, but I will deal with that on the 8th. At this point, his bond will continue. Thank you.
Everything here.
Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith.
Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam
That's the only
Prosecutor.
thing holding it.
I'm sorry, Your Honor.
It's the only thing holding him.
Yes, it is.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference, July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor. May I address the matter of bond, Judge?
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter, Judge, and I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a probation
I
sentence.
understand how
even if
sentencing
convicted.
works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to. We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a 75,000 cash as surety in this case, and we were given 75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at was a teacher at Ypsilanti High School. The victim in this case is a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked up and intervened that this concluded. The whole thing is on is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself?
And that wraps up this intense courtroom session. To summarize, Mr. Lee faced critical decisions about representing himself versus having counsel, and the court weighed his preparedness, discovery access, and the severity of the charges. Ultimately, the judge denied motions for bond reductions, emphasizing public safety and adherence to legal procedure, while outlining the consequences of the charges he faces. This case highlights the importance of legal representation, understanding court rules, and the careful balancing act judges must perform between rights and risks. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Self in Ypsilanti as a condition of bond?
I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.